Before we get into the agenda, the city attorney has actually asked for some time at the beginning, and I'm not even going to ask for a vote. Have him come up and give us some instruction.
Members of the board, good evening. Robert Sullivan, city attorney. As the chairman said, I'm here at my request to address the board briefly about the matter of North Mill Pond Holdings LLC at 1 Rains Avenue versus the city of Portsmouth. It will have an effect on proceedings this evening, so the idea was to discuss it at the beginning of the meeting. On the 9th of February, but only served this week, was that lawsuit that I just described. It is a pretty serious matter, quite a lengthy petition as land use appeals go. It is 20 pages in length. The lawsuit contains 3 counts. The city is the defendant, but actions of the planning board and to a lesser degree actions of the zoning board are the subject matter of the case. The first count is an appeal of the planning board's decision on a motion for rehearing, which occurred at the board's last meeting, and the board determined to hold a rehearing. The petition raises a number of legal questions, which sort of begin with the idea that the planning board didn't have the legal authority to conduct a rehearing. Also raises a number of very specific issues about actions of particular members of the board, and generally is a request that the court order that there shouldn't be and couldn't be any rehearing. Count 2 is in some ways a repeat of count 1, except that it asks the judge to make declaratory rulings on most of those same points, and the declaratory ruling would just be a statement by the court, not necessarily an order, but a statement by the court as to what the law is with regard to various questions, such as, can a planning board hold a rehearing? The complaint, to be accurate, is fairly vitriolic. I would suggest that all the members of the planning board read it. I don't really wish to get into any further detail about the content of the complaint at this time, because it is now the subject matter of serious litigation, and to the extent the board wishes to discuss it, I would suggest that we hold a non-public session at an appropriate time. There are a couple more points, however, that need to be made. And first off, this lawsuit makes a really assiduous claim for attorney's fees to be paid by the city because of actions of the planning board. I point this out to you because that is a rare situation. I have handled a tremendous number of land use appeals over the years, as much as anybody, I would think, and I've never seen anything quite like this. So when the board members read the complaint, I would suggest that you direct some attention to that third count, the claim for attorney's fees. There are, as I say, some fairly vitriolic comments there, and it's a very strongly worded provision. But it is actually the last item in the complaint that brings me here tonight at the beginning of this meeting, and that is because the process of appealing a planning board decision is a little different than appeal of a zoning board decision. The process of appealing a planning board decision to Superior Court calls for the appealing party to file a request for what they call certiorari to the Superior Court. And this means that before taking any action on an ex parte basis without the city being, in this case, even alerted to what is happening, the judge conducts a very brief preliminary hearing to determine whether or not to issue any preliminary orders. And the preliminary orders did issue and were issued in this case. And the order reads as follows. By order dated February 14th, 2022, Superior Court has ordered, Judge Myra Wagling, Superior Court judge has ordered, quote, proceedings upon the decision appealed from are stayed, end quote. Meaning that very specifically, the rehearing cannot go forward. The rehearing that was voted by this board because of the fact that the court has now ordered that it not happen. Beyond that, the attorneys in the case, including Attorney McCallum, who represents some abutters, have agreed that give the order its full effect. Everything is stayed. No action should be taken by anyone in connection with Rains Avenue application. No rehearing should be held, and this situation will only end when, in some way or another, a court orders it to end. The variety of remedies that the court might order go all the way from simply overturning the planning board on the one hand and not allowing anything further to happen, all the way to upholding the planning board, in which case I would think the rehearing would go on, or the court could make the decisions on the issues itself, eliminating the need for a rehearing. But we won't know that, and we won't know it for a while. The city has 30 days from the filing of this suit to file an answer. I'm advised that Attorney McCallum will be intervening in this case on behalf of certain private clients he has who have an interest in the case. And when the answer is prepared and filed, copies will be provided to you. And at that time, the best way to read it is to take the complaint, put it in front of you, take the answer, put it in front of you, read complaint 1, answer 1, complaint 2, answer 2, etc. And that's where we are at the moment, Mr. Chair. And as I say, the court has ordered that no action take place.
And as I understand it, Attorney Sullivan, that would include not even looking at the minutes with respect to that meeting.
That's right. We're trying to give this court order a full and literal meaning that no action should take place.
Any other questions for Attorney? Thank you.